So the last case we're going to do in the abortion rights area is a case from Texas. Whole Women's Health versus Hellerstedt was decided in 2016. The issue in this case is House Bill 2, which was passed in the state of Texas, that provided a number of regulations and restrictions on access to abortion. One of the restrictions required that any physician performing an abortion had to have admitting privileges to a hospital within 30 miles, and the justification for that was health and safety of the mother. Another provision required that all abortion clinics comply with the standards of surgical centers, and again, that was argued as for the health and safety of the mother. What this ultimately did is it significantly limited the number of clinics that would be able to provide abortion centers or able to provide abortions because they simply didn't meet these standards or couldn't meet these standards without significant, modification. So the issue in this case is does these restrictions of the state violate the undue burden or the substantially burdensome standard that the court has used to regulate these areas before? And so one of the important things that you should take away is this undue burden standard has now sort of supplanted itself. It is now precedent of the court, so much so that that is the issue in this case, and that's how they discuss the issue in this case. They aren't talking about the trimester framework anymore. They aren't talking around Justice O'Connor's main contribution, this undue burden standard, simply being the way by which she decided her jurisprudence in this area. But it's now the jurisprudence of the court is to deal with this undue burden standard. So in this case, Justice Breyer writes the majority opinion. And the one thing that we wanted to watch in this case was where Kennedy would come down. Remember, in the last case in this line of jurisprudence, we said that Kennedy was really the pivotal justice, that his decision, his vote in any given case going forward would really decide which way the direction of the case went. Well, in this case, Justice Kennedy sides with the liberals in a 5-3 decision. Justice Scalia had since passed away, and his replacement had not been nominated to the court yet, so there was only an 8-person court. But even his inclusion or the inclusion of another conservative wouldn't have mattered because there were 5 individuals in the majority. The court does apply the undue burden standard. And they argue that, yeah, this is an undue burden, primarily because the regulations don't provide more medical benefit than burden to access. And there's even some question about whether there is actual medical benefit to these restrictions. And that question of the medical benefit, there may be some, but it isn't clearly evident. But the burden to access far outweighs any form of medical benefit that these clinics would gain, or the state would gain, by these clinics having these increased standards. And so Justice Kennedy sides with the liberals in this regard. There is one notable concurrence, and that I want to cover, is a concurrence of Justice Ginsburg. Justice Ginsburg, during oral arguments, and I very rarely bring up oral arguments, but they're very important to this case, especially teaching in El Paso, is that El Paso featured pretty centrally to Justice Ginsburg's questions during oral arguments. And Justice Ginsburg pointed out that if these restrictions were put into place, there would be enormous swaths of the state of Texas that would have absolutely no access. And she asked Texas's attorney about El Paso, because El Paso would have no access in the state outside of what I think was the equivalent of 3 hours car ride away would be the closest access in the city of El Paso. And the state of Texas attorney responded with, well, those individuals in El Paso can simply go to New Mexico to access the procedure. And so very pointedly, Justice Ginsburg asked, well, correct me if I'm wrong, but the clinics in New Mexico don't have the same standards that are being imposed in the state of Texas. So what the state is telling me is that these standards, which apply only in the state of Texas, are purposeful for the state of Texas unless you're an individual from El Paso, and then access isn't a problem because you can go someplace that has less protection, and that's okay. And it really, that line of questioning sort of drives her concurrence in this case, when she points out that, you know, the conversation about access is really geographic in this case, and that the nature of a modern abortion happening in 2016 is monumentally different than the discussion of the right in Roe v. Wade. That modern abortions are among some of the safest medical procedures that women can undergo. In fact, she points out that it's safer than childbirth itself. And so adding the difficulties upon access to an abortion don't really serve a medical purpose. That there is no argument that can be entailed to make a medical purpose necessary, and the hypocrisy of the state of Texas in arguing that El Paso isn't reducing access because they can go someplace with less high of a medical standard in the state of New Mexico just points out that this regulation isn't about health to begin with. There are a number of judges in dissent. Justice Thomas is in dissent, and Justice Thomas says that the majority in this case really is sort of stretching the rules of precedent to get where they want, and that this undue burden standard applies to regulations in, you know, abortion in this case isn't regulating abortion, it's regulating clinics, and that's a very different thing. I'm not too certain if that's persuasive, but that's the argument he takes. Justice Alito talked about a standing issue, which I'm not going to deal with, though it was an interesting question at the time, whether the individuals who were bringing this case had standing to bring this case. But that's beyond this, and Justice Roberts just joins the other two dissents. Really what's important about this case, and what I want to point out, is that this case took place only 5 years ago. The decision in this case was handed down 5 years ago. The three individuals who are in dissent are still on the court. Justice Roberts, Justice Alito, Justice Thomas. They're still there. Justice Ginsburg has departed and was replaced by someone who was more conservative. Justice Kennedy has departed and was replaced by someone who is more conservative. Also, Justice Scalia has had a replacement. Justice Scalia's replacement is likely just about as conservative as he was, and had he been alive in this case, he would have voted for the state of Texas. So the decision in this case, the majority in this case, the 5 people who are in this case, 2 of them are no longer on the court. And those 2 individuals have been replaced by individuals whom are more conservative. So if a similar case were to come up, literally right now, the decision in this case would likely be wholly different. It would go in a very different direction. And this is why many states at this time are passing regulations more stringent than the ones that Texas did to regulate access to abortion rights, in some cases passing laws which absolutely abolish abortion rights within a state. And the reason why which they're doing so is they're looking at the constitution of the court, the ideological makeup of the court, and really thinking, and I think rightfully so, that the current court would be more willing to uphold those restrictions and really gut, if not outright overturn, the fundamental decision of Roe v. Wade. So those cases haven't happened yet. They will happen in the future. But I want to make clear that while we're ending this section right now on a note that says abortion rights are still protected and the undue burden standard is still good law, that might not be the case next year or in 2 years. And whereas this case sort of ends on an ideological trajectory in one direction, understand that significant change has taken place on the court in terms of its membership, and therefore ultimately its ideology in 2021 is very different than its ideology in 2016. And this regulation in question likely would not be good law today if it was the current court reviewing it.